you are going to be introducing a set of measures, and then from time to time you'll continue to revise or review the need for the state of disaster, essentially answering the question, as a result of these additional measures that have been introduced during the dispensation of the state of disaster, are they sufficient to help us to respond comprehensively? Not necessarily that you have resolved the question. So that's the state of disaster issue. And then the second instrument that the President introduced was the need for a dedicated executive authority to focus on a daily basis on the resolution of the electricity problem in the country. So if you like, those are two separate instruments that are meant to work together to help us to resolve the crisis going into the future. So what is the point I'm making is that no, the Minister of Electricity continues to be seized with that responsibility of reducing the severity of load shedding and its the regularity. And that's why you have seen that you have done extensive visits to the various power stations of ESCOM. We've got a better appreciation at the very granular levels on what is sufficient or what it takes for us to be able to respond comprehensively. And as the Minister has indicated, these actions are meant to serve to, if you like, accelerate our efforts to deliver in accordance with the energy action plan. So the long and short of it is that the Minister of Electricity continues to execute and prosecute the responsibilities as determined by the President. There is no relationship between the state of disaster and the tariff hikes. It's a separate, independent process. There are submissions that are made to ESCOM making a case why they think there has to be a tariff increase or a redetermination of tariff going into the future. There's a set of considerations and indices that NERSA considers, and then NERSA makes the final determination. So whether there's a state of disaster or there's no state of disaster, those determinations continues to be made on a year-on-year basis. So I'm just saying that there is no relationship. It's just a statutory obligation that from time to time, as we move from one year to the other, ESCOM will make those submissions, and NERSA, independent of everyone, makes the determination and then arrives at the conclusion, and that's what is applicable going into the future. And then the other question is whether of course the rest, the others will be responded to by Minister and DM. Is this permanent? I think what the DM has indicated is that from time to time, I think there's a revision of whether the instruments before us are necessary or sufficient to help us to respond adequately. And we have arrived at a determination where we are to say the actions, for an example, taken by Minister of Communication, DTIC, as I respond to one of the questions I think Iskopano was raising. So those are not erased, so they remain in place because those are additional instruments that were made possible during the dispensation of the disaster. And therefore, as we discontinue, if you like, the state of disaster, they remain in place because we have found them to help us to sufficiently respond to the challenges going into the future. If we arrive at a determination sometime in the future that there's a need for us to reconsider this position, there's a process in government to ventilate, assess, and make sure that methodically you arrive at a redetermination if there's a need, and you are able to illustrate that you are transparent, you are rational in that consideration, that what is before you, the instruments that are available to you at the time, including those additional measures that would have been introduced during this period, we find them to be blunt instruments, and therefore we need additional instruments. And then Cabinet applies itself, and of course through a determined process, then there will be that redetermination. So the point I'm making is that no, it doesn't follow that it's permanent in the same manner that it wasn't permanent to have a state of disaster. It's under continuous review. That's the point that I'm making. And then on the issues around the withdrawal just from Natasha SABC, the actions taken by the Minister of Finance, I think that's not our domain. So the Minister was today before Parliament and by extension before the country, trying to explain the rationale, what were the reasons why they've arrived at that determination. I think since they made that determination before the withdrawal, the National Treasury, principally through the Acting Director General, has been on various platforms trying to explain how they arrived at that determination. So I guess that's a conversation that is outside this domain of the declaration or termination of the state of disaster. It's an accounting issues around transparency, governance, and those issues were responded to and continue to be responded to by the Minister of Finance and National Treasury. And then what is the impact on procurement? So what we know, for an example now, I mean, from a ESCOM point of view, the PFMA does make provision if there's issues around emergency. If as a result of inaction, we are likely going to see, if you like, loss of life, harm to the environment, the PFMA does provide for, if you like, for us to use provisions on procurement on an emergency basis. So essentially, there are provisions that allows for deviations, and those deviations, emergency, and also those deviations have to address the issues around the agency. If urgent action is not taken, there could be, if you like, harm to critical infrastructure, and therefore you don't have to go through a competitive bidding process. That dispensation exists in the PFMA. The other area is around the sole provider. So if a turbine is produced by a manufacturer X, and then there's a component that needs to be fixed in that turbine, of course, you don't open up to everyone. You do explain yourself why I have to go to that particular manufacturer, because this is the original equipment manufacturer. He's the only one that can give me this component. That dispensation exists. So what is the point I'm making is that those provisions from a procurement point of view are made possible in the PFMA, and therefore the termination of the state of disaster has no impact on that. That the existing dispensation makes it possible going into the future. I think those are the issues that were directed at me. I'm sure DM and Minister will deal with the rest.
Thank you very much, ministers and colleagues. I think context is very important when we engage in the discussion around, firstly, the declaration of the national state of disaster, and now, of course, the termination of the state of disaster. Because if you would recall the time at which the state of disaster was declared, we were facing as a country escalating levels of electricity outages, and these were for longer periods on a more daily basis and required immediate interventions. And a determination was made to declare national state of disaster. But when a state of disaster is declared, it is subject to continuous review and assessment by the ministry, because you would know that, in fact, after it is classified as a disaster, subsequently declared as a disaster, the minister publishes a set of regulations related to the national state of disaster as declared, and enables particular executive authorities or ministers to be able to issue directions in line with the national state of disaster, because you are empowering particular ministries to be able to execute particular responsibilities. Now let's look at where we are today. There's a new executive authority that's been established that's focused on electricity in particular and addressing the issues. So it's important to be in continuous engagements with that ministry to determine whether you need additional powers to be able to execute your responsibility. And the reality is, on the basis of that review, we've determined that you don't need extraordinary measures to be able to intervene. We have determined that, in fact, you've got the measures in place to be able to intervene. We've also reviewed the progress that's been made in a number of areas, whether it's around the procurement of emergency power, whether it's around the procurement of battery storage capability, and other interventions. And we've determined that, in fact, from a procurement point of view, the process is currently underway, and some of which have been concluded, would be able to conclude within the time frame as prescribed without the need for extraordinary measures to be put in place. We've also determined the level of outages that we're currently experiencing. Of course, it doesn't mean that we don't have a problem. The outages continue, so you still experience load shedding, and therefore you need to deal with load shedding. But we've determined that, in fact, the mitigation measures currently in place are able to mitigate and continuously reduce the levels of load shedding as we're experiencing. So I'm making the point that it is on the basis of a continuous review of the measures taken to determine whether you require a state of disaster to be declared to be able to execute the responsibilities either of the Minister of COGTA, the Minister of Electricity, or any other minister that would have been impacted by this declaration of the state of disaster. And in this regard, I'm talking about ministers that would be responsible for the commercial and financial issues, whether they would require extraordinary measures. And the determination was that, we're not at the stage where, in fact, we do require to continue the state of disaster. Do we consider it in the context of litigation? Of course, you look at litigation and you ask yourself, if we don't need a state of disaster, do we need to be in court? If you don't need the state of disaster, you don't then go and brief senior counsel to say, take me to court just so that we can be in court. It doesn't make sense. You arrive at a determination that, well, on the basis of the current review, we do not need them, so we don't need to be in court. So the point of the court technically becomes moot if you think about it, because you don't need to be having a state of disaster. And that really would have been the considerations. We factored in a whole range of considerations in arriving at this determination. And this determination has been on the basis of consultations both within COGTA, with the National Disaster Management Center, but also with other departments in government. Thank you.
Thank you very much. We are going to go online now. We will come back. Who's giving us the online ones?
Thank you, the Program Director. I will take you through the online questions. The first question is coming from Nomazima Nkosi from the Sowetan. And the question is, one of the reasons why the declaration was put in place was to enable ESCOM to procure parts and service quicker. And with the declaration now terminated, how does it affect the above? And is there no change to the emergency procurement was there in need for the declaration to begin with? And we have Lamis Omaji from News 24, and the question is, with the repealing of regulations that were passed during the state of disaster, what does this mean for the fast tracking of ESCOM's application to run Kusile without flue gas desulfurization technology? And is the allowance still valid, or does it also fall away? And Terence Kremer is asking two questions from Engineering News 1. Have any actions or interventions been taken to date using the state of disaster regulations and directions? And if so, what becomes of those interventions, such as the one-stop shop under the DTIC? And this second question, could Minister Ramkhupa please outline this program of action now that he has completed a fact-finding exercise? And will any adjustment be made to the EAP and or the NETCOM roadmap to end load shedding? And Christian from Network 24 is only asking, why exactly was it decided to revoke the state of disaster? And what will be the last for now from my side, also from Network 24 by William Horn, to the Minister of Electricity. To what extent was the state of disaster enabling the supply of emergency funding to ESCOM for diesel purchases?
And in light of ESCOM's massive expected financial losses, doesn't this imply continued dependence on the fiscals for diesel purchase? Thank you, Chairperson.
Thank you very much. We're going to allow principals to take these ones, and we'll come back inside for the last round. Thank you.
Thank you very much to the online question. Just to Kenneth Creamer's question, I'm sure you have a media advisory that tomorrow, I think at 10, I'm doing a comprehensive update on the visits to the power stations and the kind of actions that are necessary to help us to respond comprehensively. This media briefing is led by Minister Nkadimeng, and the point was to communicate the decision in relation to the state of disaster. So I will be providing that comprehensive, if you like, update, and also sharing with you what the next steps are. Remember that the commitment I made to the South African public was that we'll be very transparent, share with them openly what are the challenges that are confronting us, and what is it that we are doing to attempt to resolve those challenges. So I was just saying to Kenneth, it's a matter of 16 hours, then we will be able to expand, because that I'm going to take you station by station, unit by unit. And maybe just to go to Omaji, News 24, I think this question of the flue gas desulfurization essentially is an instrument or a mechanism that is made to reduce the sulfur content of the emissions, because you know that the two coal-powered power stations, the newer ones, Medupe and Kusile, have got stringent emissions requirements, and as a result of that, the antiquated instruments that exist in other power stations are not sufficient to help them to remain within the threshold of the emissions level, and therefore they had to install a mechanism called the flue gas desulfurization. It's a 40 billion rand component that helps us to reduce essentially the amount of sulfur dioxide into the environment. And we know that as a result of a design flaw in Kusile of the FGD, that's a short name for flue gas desulfurization, there was a lot of slurry that set on the chimneys, which are the ones that ultimately take out the emissions out of the generation of power at Kusile and Medupi. Of course, the FGD will be installed much later, and as a result of that, the structural integrity of the chimney was compromised because of the amount of slurry that they packed in the chimney. And as a result, unit 1, 2, and 3 in Kusile were discontinued, and each unit is 700 megawatts. So if you like, we lost 2,100 megawatts, 2 stages of load shedding as a result of that failure. So what did ESCOM do? ESCOM then went to Minister Barbara Creasy to ask for a special dispensation to say exempt us, to allow us to bring this unit back into operation quicker without necessarily removing the obligation over a period for us to ensure that the FGD works. So as a result of that exemption, it means that we should be able to return those 3 units. The last one will come, of the 3 that are out, the last one will come online by the 24th of December, just on Christmas Eve. That's when we are going to get the, if you like, the full benefit of the 2,100 megawatts. And then just to make the point that that exemption by Minister Creasy was exercised outside the provisions of the Disaster Management Act. So that existed within the instruments that are available at the disposal of Minister Creasy. So that's the point that I want to make. So essentially, it's a dispensation that is unrelated to the existence and or termination of the Disaster Management Act. The existing provisions of the law made it possible for her to extend those provisions. Of course, the condition is that it's temporary. We need to go back to our commitment to reduce the emissions. And just to Nomazima Nkosi there, on procurement of parts quicker. I made the point earlier on in my first iteration of the responses. The existing provisions, just to be more specific, the Public Finance Management Act, the Supply Chain Management Instruction Note, I think number 20, just makes provisions on emergency, agency, and sole provider. And I've chosen to use a very simple example. Some of the big components there, the components in the power stations that can be bought off the shelves is your turbines. So turbines are produced by a few original equipment manufacturers in the world. So if you have turbine X produced by supplier Y and there's a component that is missing or damaged in that turbine, you are not going to go to other original equipment manufacturer. You are going to go to this one that manufactured it and buy from that person. So the provisions exist. So you don't need the Disaster Management Act. So you are going to act within this framework. And the point, I guess, that is being asked is that the removal of the state of disaster, is it going to undermine the agility, pace, and responsiveness of procurement? The answer is an emphatic no. And then just again going to Krima on Kenneth on your one question that you raised. I've responded to the one on fact finding to say that we'll share with you comprehensively tomorrow. So on the issues of the one-stop shop. So the one-stop shop was one of the measures that were introduced as a result of a package of interventions within the context of the state of disaster. Those remain. So they are not repealed or erased. Those remain. And it is those additional instruments that then makes it possible for the minister, of course, having consulted the PS, to say these additional instruments to the ones that we already have are sufficient for now to allow us to respond effectively to this situation. If in fact there's a need for us to, as DM Tau correctly indicates, from time to time you revisit these decisions. Are they still applicable? Can we improve? If we arrive at a determination that you need additional instruments in your or weapons in your arsenal to respond to this, that determination will be made at the point. So we're not going to preempt what that determination is. And then just to Mr. Horn, William, on the diesel purchases. So all we know is that when your base load can meet, if you like, demand, you run your peaking plants. And some of these peaking plants include your open cycle gas turbines, which consume a lot of diesel. So as part of trying to balance the system and ensure that we protect the economy by ensuring that we don't go to higher stages of load shedding, the system operator, ESCOM, makes a determination that let's run the open cycle gas turbine. And then there's a provision that is being made there with regards to the amount of money or what is budgeted for diesel. If they get to a point where they think that they need additional protection to the system to protect the economy, and therefore they need to purchase more diesel than what they had projected for, there's a process that they need to follow for them to be able to make a case to the Minister of Finance. Of course, at that time, will also be, if you like, in the equation to make a case that we think we must go this route in order to protect the South African economy from additional harm. I mean, we're at stage 3, stage 4, we're oscillating between those stages. Is that great harm, injury to the South African economy? So if you go to higher stages, is in fact additional harm, and that's why it's important that from time to time we help in running the peaking plants to protect us from going to higher stages of load shedding. The point I'm making is that if those allocations in rent terms are not sufficient, and there's a case, and we're convinced that we have a strong case, the Minister of Finance says, but ESCOM, make a case. Why is it that you need the additional allocation? And that determination is not made by the Minister of Electricity, it's made by the Minister of Finance on the balance of evidence that would have been put before him at the time. Thanks.
Let's come inside. We are starting with yourself there.
It's not from the report. I would just like to follow up on questions of my colleagues that I don't think were answered. My colleague from Reuters asked about contracts that were concluded during the state of disaster using this disaster legislation and the amounts involved. And then Minister Ramakopa, I think we understand how diesel is used and how it usually works, but I think the question was diesel used using the state of disaster or money for diesel using the state of disaster regulations and legislation, and if so, how much was it?
Okay.
Thanks. Danini Rosas from Business Day. To the Conference Minister, it's really not clear to me yet if there was any interventions, any actions, any new regulations put in place under the state of disaster that could not have happened anyway without the state of disaster. Can you maybe give one or two clear examples of what interventions were made under the state of disaster that would not have been possible without the state of disaster?
Last, okay.
Again from Kaya FM. Minister, in terms of the determination of the state of disaster, is one of the reasons, or are you able to elaborate on the implementation or the development of the energy mix program? So as it relates to independent power producers, is there some is it running now? Is there some legwork that's been done that's also forming part of the reason why it was terminated? So just in terms of that energy mix program development, does that have some part to play in the ending of the state of disaster?
Thank you very much. That was the last question for the day. Minister.
Well, just to Mr. Slabert, Ms. Slabert, my apologies from report. And Kopano, sorry, I missed that question earlier on. My sincere apologies. No, I'm not in a position to compute what is it that ESCOM has procured, invoking the provisions of the state of disaster. And I'm sure that once that is made available, at least to me, I'll be in a position to share with you. I'll attempt to get that between now and tomorrow if I can, but I'm not in a position to now as we speak. And then there was the question, that question, what was the question again? Yes.
It was in relation to independent power producers, so the energy mix program.
Oh, okay. You know, as we were speaking, I recorded it here, I didn't write it down, so my sincere apologies. So you know that what guides the energy mix in the country is the integrated resource plan of 2019, of course, is in the process of being revised, and it does determine the technologies that we are going to deploy going into the future. So fossil fuels still continues to be a dominant part of the energy mix. So by fossil fuels, I'm referring to coal primarily. Gas is a part of that, and we also have nuclear. And it does project that the increase of the share of renewables in the total energy mix is going to grow and grow exponentially. And there in particular, we're talking PV, solar, we're talking battery storage. Those go together for purposes of giving you a better chance of providing for base load, because we know PV is intermittent, and then you can store the energy at the right time when you need it. You release it from batteries, and that's why it gives you an opportunity for you to stabilize the grid and not go outside the threshold of 50 hertz. And then part of the energy mix is also wind. So what has been the case now? So if you go to the energy action plan, it does envisage, amongst others, so it's underpinned by 5 key interventions. Of course, the one is about the existing fleet, and ensure that you sweat the existing fleet. In technical terms, what we improve the energy availability factor, so that we were able to get closer to the installed capacity of these units at the multiple power stations that we have in the country. And then the other anchor of that is the acceleration of new generation capacity, which is your question. So I thought it's important that I provide that context that is part of the IRP first, and then the Energy Action Plan does envisage the fact that you need new generation. That new generation is going to come from the renewables. We know that we have run about 5 bid windows. There's a pipeline of renewable energy projects, and some of them are at various stages of the project life cycle. Some of them have reached financial close, some of them are already in the grid, some of them are producing stranded electrons. When I say stranded electrons, is the absence of the grid to evacuate these electrons so that we can benefit from that generation. And that's why one of the key considerations at ESCOM is to ensure that we are able to strengthen the grid, expand the grid, so that we are able to evacuate the electrons. So your question is, are we still remaining within those parameters? There's an existing piece of legislation, by the way, just on the existing, pipeline of renewable energy projects, to those that they require an accelerated path in relation to licensing and permitting issues, such as water use licenses, environmental impact assessment. You did not need the state of disaster to accelerate those. You need to invoke the provisions of the Infrastructure Development Act. In terms of that act, we declare this project a strategic integrated project. And in terms of that act, the answer that we must get to resolve those permitting and licensing issues, it's 59 days. So what's the point I'm making? The fact that we are terminating the state of disaster does not degrade our ability to accelerate the delivery of new generation. Doesn't do that at all. We can draw from the provisions of the Infrastructure Development Act. We designate those as the strategic integrated project, and we are able to roll them. What will be a big constraint as I speak to you is a grid capacity to evacuate the electrons, and is a function of where are these renewable energy projects located. If they are located in spaces where there's additional grid capacity, they'll be connected quicker. But we know that the renewable energy complex in the country is in the Northern Cape. There's insufficient grid capacity to evacuate those electrons, and that's why part of that conversations with ESCOM is us strengthening the grid and making it possible for us to benefit from the previous bid windows of renewables. And in this way, you'll see when we talk tomorrow, we are in a position to relieve the country of, if you like, higher stages of load shedding, opening the path for us to ultimately defeat load shedding and get the economy of the country back on track. Thanks.
Okay, thank you very much. I think the last question was to me. I think firstly, let's look at the question is more about what was utilized by government in its current form, and I think the focus is more on the energy generation or any energy supply by ESCO, but not also looking at what COGTA will do, looking into partners who utilizes power. For example, municipalities ordinarily, on any requirement that they need to do to service their waste treatment plant, they will have to follow a process, apply, and do all that. What does it happen when, on a day-to-day basis, power trips? It has a potential of damaging the infrastructure. So it might not necessarily be an application that has to be made through the disaster, but by applying the disaster, you unlock quite a lot of things. Building of tankers into school by municipalities for the supply of water to learners. The same tankers to hospital for the supply of water to patients. Boreholes without necessarily following a process and even reviewing the budget for the supply of patients and any other. So it's not a disaster looking only at it, also had the word impact on health, social services, and many. So if you look at it in that way, it will then mean if there is a trip and a destruction of infrastructure now, the municipality can only repair it in 3 months, following its own cycle, while water is a day-to-day supply. And this has assisted in doing that. Even ESCOM, in terms of isolation of points, where power may not necessarily be removed, particularly at the hospitals and care centers where our elders are found. That was a great deal of what this has been able to assist, actually, into a mechanization of a system, now 2 ways. INEP in the energy provision to ensure that we assist municipalities, now to put solar into those systems. So they're not going to be going through the same process that they need to be able to facilitate that they are able to provide water or treat their treatment plants on a day-to-day basis. And I think that's the major benefit that this has been able to achieve. And of course, it couldn't have happened if there was no assistance with regard to the Ministry of Electricity. And it continues to happen. Hence, we are saying it can be reviewed at any other given time. That's the nature of the Disaster Management Act. Actually, by its very own nature, it compels you after every 30 days to go and look as to whether today is the same as 30 days ago and reallocate or review or do away with it at that particular time. Thank you very much.
Thank you very much, colleagues. We have come to the end of the briefing. We thank you for coming. Thank you.
They might have to come this side to address the participants.